I suppose not quite going from the ridiculous to the sublime or the sublime to the ridiculous. Maybe it started with the sublime. I'm going to go to the practical. So I suppose my expertise isn't particularly in CEDAW. I'm a working solicitor. I've pretty much picked up what I know about human rights from working with clients and trying to find practical solutions to their problems. And human rights is very useful, and the language of human rights is very useful in that regard. So this morning, I'm just going to set a little bit of context in terms of linking the domestic sphere of human rights protection with the international sphere of human rights protection, identifying some of the barriers that we experience in accessing what seems to be the promise of international human rights law, and how do we relate that to the individual on the ground in the domestic setting. And then I'm just going to look on a somewhat more positive note at possible avenues we can explore for using international human rights law at home as such. So, thank you. So in the domestic sphere, we've heard the Irish Constitution referred to both, I suppose, negatively and positively this morning, but it is the first statement of the state. It is the primary human rights, I suppose, the primary human rights instrument of this state, and the fundamental rights provisions are contained in Articles 40 to 44. Sometimes the Constitution is perceived as blocking rights, but at the same time there are very positive statements about human rights in there as well, so we shouldn't ignore it. There's domestic legislation, some of that derived from constitutional rights, some derived from elsewhere. I'm particularly emphasising here that we have a quite sophisticated anti-discrimination code in terms of our equality legislation. There are the Equal Status Acts, which protect against discrimination in the supply of goods and services, and then the Employment Equality Acts, which obviously address issues of discrimination in the employment context. But I think they're of core importance in the context of what we're talking about this morning. I should also refer there, in terms of domestic legislation, to the European Convention on Human Rights Act 2003, which is a form of incorporation into domestic law of the European Convention on Human Rights and gives it effect in the domestic sphere. And then, going on from that, the courts pronounce on matters of law, clarify and develop the law, and that all becomes part of the rights protection landscape that we experience. So that's the domestic sphere. So outside the borders of the state, we have the international sphere of human rights protection. So we have international human rights law, we have the treaty provisions and general comments that flow from them. So this morning we heard about CEDAW and the general comments, the expert comments there, giving flesh to the particular articles of the convention, which are very important. But one important point here is that Ireland is a dualist state. And Article 15 of the Constitution says that the only body that can make laws for the state is the Oireachtas. So just because Ireland ratifies an international treaty doesn't mean that treaty becomes automatically part of our domestic law. And that can be a very frustrating reality for all of us. We're told we have these rights. We can look to CEDAW. It's a statement that any woman could look to and say, well, I have all these rights that I can claim, and yet if she goes to her local court, she can't necessarily assert them in a straightforward way. So that's one of the big issues that we have to address. But being aware of it means that you can negotiate that space and manoeuvre around it and still use those international instruments. So in terms of regional protection, as has already been mentioned, we have EU law, and EU law is somewhat different from other, I suppose, laws that come from outside the state, in the sense that by virtue of changing our constitution, we have given supremacy to EU law. So there isn't really a question of, oh, does our constitution clash with the EU law? How do we negotiate that? It really doesn't matter. EU law has supremacy in the state where relevant. We have the treaty provisions setting up the EU institutions. We have the jurisprudence of the Court of Justice of the EU. And most recently, since 2009, we have the Charter of Fundamental Rights and Freedoms of the EU. This is probably, the case law under the Charter is still developing, but it is very significant. And I've just highlighted there, it's I suppose if you read it, it looks like a new generation human rights instrument just because of some of the rights that are enshrined there, like rights of children, the rights of the elderly. It also addresses disability. In relation to equality, in Article 23, it enshrines gender equality in all areas. It particularly emphasises employment, but it does refer to all areas, and does allow for positive discrimination for the underrepresented sex. So obviously it's equal in terms of men and women, but whatever the context is may dictate who can benefit from that. There has been case law of the Court of Justice of the European Union that very much limited the scope in which a state could actually engage in positive discrimination, particularly in employment law. And I'm not really sure as yet whether there's been a case where the state sought to defend positive discrimination by drawing on the Charter, which would seem to give a broader scope for that positive discrimination. Then there's the Council of Europe, and in particular the European Convention on Human Rights, which, as I mentioned, has been given a certain form of force in the domestic context. So I am going to skip over this. This is really just sources of international law and where it gets its legitimacy from, but I don't think we're really concerned with that this morning. So, in seeking accountability from the state in relation to international human rights law and compliance, what can we do? So some of this has been referred to already and is familiar to you. So we have the periodic reporting cycles under the various treaties, where expert committees reviews the performance of the state over a particular period of time. And within that, obviously, there are opportunities for shadow reporting, which is obviously something that's very significant in today's discussion. And there's the mechanism of the list of issues, which nets down the issues to be addressed. So, then there's the role of national human rights institutions and NGOs in participating in the dialogue around that periodic examination of the state's performance. And then we come down to the opportunities for making individual complaints and collective complaints, and I'm going to discuss that in more detail in my paper. But finally, I just refer to the UPR, which I often think is kind of an opportunity to have another bite at the cherry, so you get your concluding observations at one point, nothing's happening, what am I going to do? Well, raise it through the UPR, the Universal Periodic Review, which goes in a 4-year cycle and involves a peer review between states in terms of their human rights performance, results in various recommendations which may be accepted or rejected by the state or put under some kind of consideration, but it does involve another opportunity to raise a particular issue where maybe it isn't getting traction at the domestic level. So I'm just listing there the various human rights treaties to which Ireland has signed up, just referring to the Universal Declaration of Human Rights, which is often said not to be binding but may well have the status of customary law. Then we have the Covenant on Civil and Political Rights, and I suppose in terms of women's reproductive rights, we're most familiar recently with a complaint taken by Miss Amanda Mellett in relation to access to abortion in Ireland, where she was pregnant and found out that the fetus had a fatal fetal abnormality. I know that's a contested term, but just for shorthand here, where she was obliged, she wanted to access termination, didn't feel she could go on with the pregnancy for obvious reasons, was obliged to travel to the UK with all that entailed for her, and I think part of the context was that she wasn't financially particularly well off, so this actually put her under considerable financial pressure on top of all the emotional cost to her in terms of the travel and having come back to Ireland and the arrangements involved in that. So the Human Rights Committee looked at her complaint, and this wasn't a complaint that she had brought before the domestic courts. She went straight to the Human Rights Committee with her complaint, and they found that she had suffered discrimination and also inhuman and degrading treatment. And that's obviously had very significant repercussions at the domestic level in terms of putting pressure on the state to address the particular situation of a woman in that circumstance. We have ICESCR, the Covenant on Economic, Social and Cultural Rights. There is a complaint mechanism under ICESCR similar to all the other treaties, but Ireland hasn't ratified it and appears to have no particular plan to ratify it. The Convention on the Elimination of Racial Discrimination, the Convention Against Torture, the Convention on the Rights of the Child, where Ireland has very recently ratified the complaints mechanism, which is a positive development. We have CEDAW and the complaint mechanism there, which has been ratified. And then most imminently, the state plans to ratify the UN Convention on the Rights of Persons with Disabilities. That has a complaint mechanism as well, and the state says that it will also ratify the complaint mechanism. And just referring back to Violetta and the kind of cross-fertilization between the human rights treaties, it is noticeable that there's a very specific article in the UN CRPD on the rights of women with disabilities, which will obviously cross-fertilize with CEDAW as well, no doubt, into the future. So turning now to CEDAW itself, having set that context, the complaint mechanism under CEDAW is contained in its optional protocol and provides that the expert committee that supervises compliance with CEDAW is mandated to receive communications from individuals or groups submitting claims of violations of rights protected under the Convention, and also separately to initiate inquiries into situations of grave or systemic violations of women's rights. And this must be based on receipt of some form of reliable information. As far as I could see, and I'm subject to correction on this, Violetta can tell us, I've only seen one inquiry on the website, but maybe there are more. I don't know if there are more. 3. Oh, okay, very good. So obviously the individual complaints are quite distinct from the inquiries, which obviously look at very serious issues, but also systemic issues that obviously affect a large group of women in a particular context. So in terms of making a complaint, first the person making the complaint or the group of individuals making the complaint must be a victim of the particular harm complained of. Now, there is some nuancing in relation to that a representative action can be taken, but it would appear that there would have to be some form of justification for why a representative is taking the action rather than the complainants themselves or the victims themselves. The complaint must be in writing, must not be anonymous, and they're all straightforward enough. The complainant must have exhausted domestic remedies unless such remedy is too prolonged or unlikely to provide a remedy. Now that is a huge hurdle, I think, in terms of getting as far as the CEDAW committee, and I'm going to look at that in a little bit more detail. Another point here is in relation to the admissibility criteria, and there are a number of other admissibility criteria, but they're straightforward and obvious and common sense enough. But one of them is the temporal limitation on bringing a complaint. So it isn't possible to bring a complaint in relation to an issue that was done and dusted before ratification of the convention by the state, or indeed before ratification of the optional protocol. And Ireland ratified the optional protocol in 2000. So in that regard, and I think it's natural with any rights movement where there's been historic injustices, it's only when the language of rights is being engaged and when people begin to seize their rights that those historical injustices begin to come to the fore. And I think it's really only now Ireland is beginning to look at its own history in relation to the treatment of women. So we've had the Magdalene laundries, the treatment of women in relation to childbirth and symphysiotomy, and other issues, and no doubt other issues will come to the fore in the future. But there is a difficulty there as to how you seek redress for those issues where you have this temporal limitation. Now, I think the Magdalene laundries is a case in point in terms they could give a master class in terms of the Justice for Magdalene groups as to how you seek justice at an international level. But that is an issue that has to be addressed in thinking about bringing forward a complaint as well. So now, coming to the exhaustion of domestic remedies, and I've taken a quote here from the committee itself, where it looked at one particular communication which dealt with a complaint from a woman who had lived in the UK, had moved away from the UK. She was a UK citizen, but she was seeking citizenship for her child, and she was treated differently as a mother than the father would have been treated if he was a UK citizen, if that makes sense. So she was claiming discrimination on that basis. But it was found there, and it was stated, in line with the long-standing jurisprudence of other international human rights treaty bodies, in particular the Human Rights Committee, the CEDAW committee considers that authors of communications are required to raise in substance before domestic courts the alleged violation of the provisions of the Convention on the Elimination of All Forms of Discrimination against Women, which enables a state party to remedy an alleged violation before the same issue may be raised before the committee. So the person must first raise in substance their complaint before the domestic courts, unless there's no point doing so, of course. That doesn't mean that the person has to bring a claim on the basis of CEDAW before the domestic courts, but the core of their complaint must have in some way been raised with the state. The person must have sought in some way to seek a remedy for it before they can ever go off and make a complaint to the CEDAW committee. That has, if we look at the European Convention on Human Rights, it has a similar provision, and most cases are deemed inadmissible simply because the person didn't exhaust domestic remedies. But how available are those domestic remedies to most people? So if you're looking at a piece of law in the Irish context that discriminates against women and a woman wants to challenge that, it means she has to go off to the High Court. Does she have the means to go off to the High Court in the first place? Can she get access to the legal representation? If she does, can she run the risk of an adverse costs order against her if the state actually wins its case before the domestic courts? And I think the Louise O'Keeffe case that many of you are probably familiar with, where she took the case in relation to her abuse in a national school, but had to go through a very traumatic process before the courts before she ever got to the European Court, and her final vindication in terms of her human rights. This is a really huge issue, and I think in the Irish context, cost is probably the biggest thing in terms of going to the courts, and it can be an insurmountable issue. So I'm not sure what argument you can raise there, but I think it's very unlikely that cost alone would be sufficient for the committee to look at the complaint without it having been aired in the domestic context. And that's why I want to swing back to something earlier and the importance of our equality legislation in terms of litigating claims of discrimination. The Workplace Relations Commission is now dealing with those complaints, and it's a somewhat unfortunate fact it doesn't refer to equality, but nonetheless it's there, it's free, it's a free avenue in which people can litigate their issues where they feel they've been discriminated against. It's accessible. So it is important that we kind of go back to basics and make sure that if we think we're on the long road to the CEDAW committee, that we start at that level. So just another few points in relation to the complaint mechanism under CEDAW. Interim measures are available, so once you have submitted your complaint, you can ask for some kind of interim measure if there's some ongoing threat to your rights that's serious, and that would involve a communication to the state in terms of taking action. The examination of the complaint is in private, and the views and recommendations of the committee are then submitted to the party. The state then has 6 months to respond in relation to those views and recommendations, and this may in due course be followed up in the periodic reporting cycle. There's also protection from victimisation, so because you bring a complaint, shouldn't mean that you can then be victimised by the state, and that's specifically addressed under the optional protocol. So, taking all that, we can see that some of the factors inhibiting the use of international human rights law instruments are first the need to exhaust domestic remedies. There may also be a perception that the remedies are inadequate. Now, for some people to get a statement from an international human rights body confirming that their rights have been violated is enough. But that may not be sufficient for everyone. And it doesn't lead to the type of tailored remedies that you can get through a domestic court. It should obviously lead to a process at the domestic level, however, in terms of vindicating those rights, but that isn't an immediate consequence. And also, again, just coming back to the dualist nature of our legal system, where there's no immediate connection between the domestic sphere and the international sphere. So, how do we get around this? Well, first, we really need to be raising these human rights arguments before our domestic courts. And this is probably very much addressed to the lawyers in the room. But these are some of the ways that you can raise these arguments before the courts. You can't go straight in and say, Judge, I want you to adjudicate on Article 8 of CEDAW. He'll say, or she will say, I'm not doing that, bye-bye. So you have to be a bit more sophisticated about how you get it in there without being too obvious about it. So there is a presumption of conformity between Irish law and international human rights law that can be relied on. You can use international standards as a form of so-called persuasive authority. So your argument here is there's a particular right under the Constitution, there's a right to equality under the Constitution. How do we understand that? Well, we have an instrument at international level that tells us a lot about equality, whether it's gender equality and so on. So I'm not saying that you have to adjudicate on that. All I'm saying is it'll be very helpful to you, Judge, in deciding what the issue is here and deciding it under our own Constitution. That works reasonably well. Once you're respectful of the limitations on the particular court, they will be open to listening to those arguments so long as you put it in the right packaging. And then using human rights law as a source of law to shed light on unsettled law. So if there's something that's unclear in the domestic context, you can say, well, this has already been tackled at an international level. And this will be really useful to you in deciding what it means at a national level. And I suppose an example of this was a particular case I was involved in around in relation to imprisonment for debt for a contractual debt, which is prohibited, and it was accepted it was prohibited, but the case was around the processes by which somebody was protected from being detained on foot of breaching a contractual debt. And within that, there had really been no case law at an Irish level in relation to what that meant. So practically 90% of the argument was around looking at international examples of where other courts had looked at this particular issue, and concluding observations under the ICCPR from the Human Rights Committee. It's only one or two lines in the judgment, but ultimately it's the judgment in terms of striking down the domestic laws which didn't provide enough protection. So it is really important. Just for the purpose of this talk, I took a quick check on the court's website and looked at judgments and put in a keyword search under CEDAW. I came up with two cases. One case where CEDAW was referred to in the most fleeting way possible, and the second case was a case that's been referred to already by Patricia, Moen and Ireland. And before I come to Moen, the reality is CEDAW isn't being used before the domestic courts. It really isn't, and it deserves an outing there. So it's worth bearing in mind. The Convention on the Rights of the Child, UNCRPD, obviously the ECHR and the ICCPR come up much more often. So CEDAW for some reason is a Cinderella in that context. So I think that's even before the UNCRPD has been ratified. So there's something going slightly askew there. In the Moen case, it was the state itself that relied on CEDAW as justifying gender quotas in relation to nominations for election. And I suppose it's kind of funny to note that the plaintiff, when I looked at it, the gender quota applied to both men and women, but the complaint was about the women's gender quota, not the men's gender quota. So there you go. So it's worth reading if anybody gets a chance to read it. But it is very positive to see the state itself relying on CEDAW as justifying a proactive measure, and they're to be commended in that regard. So I am not going to spend very long on this, but there are other avenues open to civil society and other actors in terms of raising international human rights standards, intervening before the European Court of Human Rights. There's also an opportunity where there has been a judgment against the state. An NGO, any entity at all, can make submissions in relation to how the state complies with that judgment. And I suppose I'm pointing that out here because there was a judgment against the state in relation to reproductive rights in the A, B and C case. So it would have been open in that context for NGOs with a particular interest or groups or individuals to make submissions as to how the state should actually comply with that judgment. It's a very accessible process. It's not difficult at all to make a submission. Intervening in cases before the domestic courts, there have been some slight developments there around NGOs participating as an amicus curiae, and that could be looked at as well. Also, NGOs could be called on to give their expertise in a particular case, to give evidence. I refer to the Human Rights and Equality Commission there and the powers that they have in terms of advancing rights, as I've referred to the EU Charter as well, probably underexploited at this stage. In terms of the Constitution, this has already been referred to by Patricia and explored, but one of the thoughts I had was in replacing Article 41.2, 41.1, sorry. 41, yeah, I should know. But I think the amendment or the referendum that we had in relation to children's rights is quite interesting, because we now have a statement of children's rights in the Constitution. Where are we going to figure out what those rights are? It seems to me that when that constitutional amendment is relied on, the state is, or the courts are going to have to rely to some extent at least on the CRC, on the Convention on the Rights of the Child, to actually understand what do we mean by children's rights. It's not set out in the Constitution. So I just wonder if there's an example there that we could all be thinking about. Finally, and I know I don't really have time to discuss this, but I do want to highlight the public sector duty. So the public sector duty is a new provision brought in under the Irish Human Rights and Equality Commission Act 2014, was enacted in November 2014, and there's been some specific work done by IREC in terms of the National Human Rights Institution and Equality Body, and also on the NGO side by the Equality and Rights Alliance, in terms of elucidating what does that public duty mean. But it really means that the consideration of human rights and equality should be front-loaded into the considerations of public bodies when they're engaging in decision-making, policy-making, and so on. I think there's opportunities there to get in those international human rights standards. There may be technicalities around that, but I think in the spirit of the public duty, I don't think anybody can reject international human rights standards as a means of informing that public duty and creating an ongoing dialogue between the state and civil society in terms of what does human rights mean, how do we measure the impact in terms of decisions and policy making, and how each public body must show they're complying with it. It's not a tick box exercise. They must show they've had meaningful engagement with the human rights standards involved. I'm going to finish there because I know I'm out of time, but thank you very much for listening.